thank you guys for having me. It's an honor to be here. I've attended many of these to get CLE credits, so I'm happy to be as a presenter today. So the topic is what every attorney needs to know about probate, and I do mostly estate planning, but I've done a bunch of probate. So part of what I'm going to talk about is how to avoid probate and what's involved there. So quick disclaimer, everything here is for information only. It's not legal advice. And if you have a specific legal question, you should consult with a licensed attorney. All right, so just to quickly have an overview of what we're going to discuss, I'm going to talk about probate, then I'm going to talk about trusts, minors. So I assume that most of the practitioners here are real estate attorneys, but I think there might be also others. So I will try to focus some of the conversation on, if you're a family law attorney, how probate and estate planning could affect you and your clients. Personal injury attorneys, if you do any personal injury work, why some of this is really important. We'll talk about inheritance, subtrusts. We'll talk about supplemental needs trusts, and just to make it fun, I like to share some celebrity estates that we can all kind of relate to or get excited about. So quick, again, review of me. I'm Leslie Sultan. I'm a working mom. I have two young children. They're minors. I've had my business since 2010, and we have a mostly virtual practice with offices throughout New York City and Long Island. All right, so hopping in, the first thing we want to talk about is probate. And I like to start with giving the history of probate because I wasn't aware of all this when I started practicing. And there's a big sort of misconception, especially amongst the communities, that, you know, family's going to receive everything and this court's just set up for the families. But the reality is it's not. It's really set up for creditors. And this goes all the way back when the laws were coming over from England, and really how to establish how people can collect, how creditors can collect money when someone dies. So quick, definition: probate is the court process required to distribute or take over someone's assets after they die, with or without a will. With a will, we call it probate. Without a will, we call it administration. It's all done through the surrogates courts in New York. The petitions are similar, different boxes you would check and different processes for each, but overall similar. And so back in England, would be around the time of church and state, there had, the separation of church and state, where before there was debts went to the children. So if somebody owed a debt to someone, they could go after the children and sometimes the cousins and siblings for that debt, which became quite a burden for families. So at some point, they did away with that system. You know, if you're interested in the history, I would say dive deep. I'm not a history buff, but I like to just present some of this. So because we are living in a credit-based system, right? We need credit as if we want to buy a house, if we were sick and we needed to pay medical bills, we want to be able to have, our economy depends on credit. But creditors need to know that once somebody dies, they have a way to get reimbursed. Otherwise, they're not going to lend to older people, sick people, or a variety of people. So the probate court sort of developed in a way to create an opportunity for creditors to come in and stake a claim against the estate. So they are always going to be paid out first before the family. Okay, so this is the big thing that I have to explain to families all the time. It's basically a lawsuit that you file against yourself on behalf of the creditors, and it's paid for out of the money you've saved, and that's now going into the estate. So family has really nothing to do with it. They get whatever's left. Probate courts are all about the creditors. And that, for this reason, it's public. So anybody can get access to the court filings. And that's why we know a lot about some of these celebrities, because once it's filed, it's public information. I have a lot of real estate agents contacting me when something's filed to say, hey, I saw you filed. Is there a house that I could sell? Right? So it's public information. So always warning clients, if you're not doing proper estate planning, the world could be on notice of what's going on in your estate. So reminding people that it's public. And again, the family only gets paid after the creditors get paid. So I think we went over this, the history a little bit. Yep. So I'm going to move on. Oh, I do have a podcast, was mentioned. If anyone's interested, I did a wonderful interview with another attorney, Yasha Saba, out in California, who really goes through all the details of this, which was fascinating for me. So there's the QR code if you want to scan it and listen to it. It's a little lengthy, you know, on a long drive, you could listen to it, but I had a great time interviewing him and listening to it. All right, so once we get to court, just so we all understand, amongst creditors, there's a priority, there's hierarchy. So this is the Surrogates Court Procedure Act, SCP Section 1811. So if you're ever having to help a client figure out what's going to get paid first, you know, you would look to that versus funeral expenses, then federal and state debts, taxes, docketed judgments, and then bonds, notes, and bills. So within each category, there's not necessarily priority. And then again, only after all of those debts are paid can the family distribute. So make sure if you're helping somebody to collect against an estate, it's got to be a docketed judgment. It can't be a summons and complaint or a note, right? It has to be a judgment in order to get priority. Okay, so the big question I always get or I hear is, but I have a will, doesn't that mean I can avoid probate? So of course the answer is no. A will has to be verified and acknowledged by a judge. The court has to be able to say this will is valid, these witnesses actually saw it. Most importantly, people have to have an opportunity to contest it. So a big problem with wills is once they're submitted to the court, everybody has to be notified and have an opportunity to say, well, that was done under undue influence, or that was done with duress, or there was no capacity. So of course, this creates more delays. So no assets can be transferred until it's completed, you know, through the court system and certificates are issued. No rents can be collected. So if there's a homeowner and they have rental income, that is just gonna basically start wasting away. An application would have to be made separate from the actual petition to collect the rents, and no expenses can be reimbursed. So it basically sits there wasting the assets until the administrator is appointed. So for families, it's really important that either beneficiaries are named on account so that at least there's some money to pay the attorney to probate the will. We've seen really unfortunate situations where families have no access to the money. They're not able to collect the rents. Of course, the tenants somehow don't have the money 9 months later when it's time to pay, and it can become a big problem. So we also have seen where even once somebody's appointed, there might be limited letters. The letters are restricting a sale, so then you have to go back to the court for permission for a sale or a transfer. And again, a misconception with wills, everybody gets notified, even if they are disinherited, because they have to have an opportunity to come contest it. So of course, what if I don't have a will? As most of you know, then the state has a plan for you in intestate succession. That's EPT section 4-1.18. And again, there's a hierarchy of who's going to inherit. So if I'm married with children, it's going to be a split between my spouse and children. If I have no spouse, no children, it's going to go to my parents. If no parents, to my siblings. If no siblings, to my nieces and nephews. And it kind of keeps going like that all the way out to cousins, which of course can get very complicated. And sometimes we have to have what we call kinship hearings to determine, you know, who are the heirs and who can receive when there's no close heirs. Usually the courts require a bond when there's no will. So now we're adding more expenses to the proceeding. And again, nobody can access the funds until an administrator is appointed. And the heirs from a generation, there's no lapsing. So I can put in my will, I want everything to go to my sister, but if she's not alive, to my best friend. Okay, but in the case without a will, there's no lapsing. So if I name if I did nothing, my sister would probably inherit, but if she's passed away, now it's going to go to her children. So this can get complicated if that was not my intentions. Or her spouse, which may not have been my intentions either. All right, so for the real estate attorneys, and I may or may not have seen this a few times in my real estate practice. Client comes to you and they say, well, I want to add my child to the deed because I want to avoid probate. I want to make sure they inherit it. Can't I do that? So the automatic, the procedure for that would be creating a new deed, adding the child, mom or dad passes away, child is now the sole owner. So does that avoid probate? The answer is yes. Adding their names will avoid probate. So it is a probate avoidance tool. And they can be added as joint tenants or tenants in commons. And obviously you'd want to distinguish those for the vesting purposes, joint tenants being automatic transfer. But I want to make sure you're aware of the cons of this. So when somebody inherits a property, either through a trust, through a will, or doing nothing, through the state intestate laws, they get what's called the step-up basis. Step-up basis is really important because if I bought the property in 1980 for $100,000 and now it's worth $1 million, there's a gain of $900,000. So if they inherit it, they get the step-up basis. So the basis that's counted for tax purposes is no longer the purchase price, but the date of death price, which is a great advantage for my heirs that they can turn around and sell it and not have to pay a capital gain. If I were to sell it during my lifetime, I would pay a capital gain on some portion of that 800,000 or whatever is in there. If I've added my child to the deed, it's as if they were the original purchaser. So they lose that step-up basis. So this is really, really important and should be considered heavily by the client before we add their child's name to the deed, okay? So of course, the other things to consider is if you've named them as a joint owner, you've now exposed the assets to any creditors of the new joint owner, the child. And of course, if the parent has left their name on the deed, it could become an asset for recovery for Medicaid if the parent had needed to go on Medicaid in a nursing home. So we like to avoid adding children to the deed unless it's absolutely necessary for some reason. All right, here we go. The TODs, transfer on death deeds, which is of course the big topic. Little background amongst estate planning practitioners. There's a lot of back and forth on this. I'll just say the recommendation is try not to use them until it kind of works its way through court. My understanding is that the transfer on death deeds were pushed by service agencies who are saying estate planning can be really expensive for some people. It's a deterrent. People aren't able to afford to hire an attorney. This allows people to make sure that that one big asset transfers. So the intention was good. The other side is saying this was kind of rushed. There are transfer on death deeds in other states, but this legislation does not mirror those. It's drafted differently. It's not fully it seems like it's rushed and doesn't fully pan out all of the things that could go wrong. So hopefully this will morph over time and improve because it is a potentially great tool, but the recommendation is try not to do them at this point. So the pros are obviously it does avoid probate. So it's ideal for families who cannot afford estate planning, right? So they're going to file the transfer on death deed upon their death. Their child would inherit the property and it would get the step-up basis. So that's the plus, and they would avoid the capital gain. The grantee has the right to renounce all or part of their interest as long as they do it while they're alive. The owner still retains full control of the property. So instead of transferring the property to my child, I still retain, during my lifetime, I'm still in control. I could still mortgage it. I could sell it if I want to. The transfer only takes place upon death of the owner. There's no consent required from the grantees. And of course, the creditors of the grantees, the beneficiaries, cannot collect against the asset. So the cons, of course, are if there's multiple beneficiaries on a transfer on death deed, that can lead to disharmony. Unfortunately, we see a lot of these in surrogates court. 3 people in the house now, 2 people want to sell, 1 person wants to stay. There's a fight. If it's done through an estate plan, there's a fiduciary who can make a decision. In this case, there would not be. It would just wind up in court through a partition action. And of course, there's no details for what if one of those grantees dies. In this instance, as the legislation's written, it would lapse and it would remain in the grantor's estate and wind up in the surrogate's court. There's no supplemental needs provision, so this is a big one. So let's say you wanted to leave it to a child and that child becomes disabled. Now they have received a huge gift that could disqualify them if they're receiving government benefits. So ideally, we want gifts to be able to go into a special needs trust for any beneficiary who might need it. And if there's multiple owners and they try to do a transfer on death deed, the remaining owners can revoke when one of them dies. And so it's only effective upon the last of those to die. So you can see there's a lot of cons. Again, this is still new. If you want to be that attorney who's carving out case law, go ahead. My recommendation is, I will not be doing it. But if you're considering it, I would highly recommend reaching out to Judicial Title. There's an email address. Send them the questions, explain the scenario, and maybe they can make a different type of recommendation for you. So moving on. Going to get into establishing a trust, because that is one of the ways to avoid probate and all the public stuff going on and all of the hassles involved with the surrogate's court. So a trust is basically a legal document where, similar to a will, and everyone knows what a will is, it's instructions for distribution of your assets. And if you own a house, basically you transfer the house into the trust as well. It's a deed transfer. All the bank accounts get retitled, and or the beneficiaries on the accounts become the trust. The beauty of a trust is if I'm doing a revocable trust, I'm still the trustee. I'm in charge. I'm the grantor and the trustee, so I get a say in how everything is done. I'm writing the checks. I can sell, all of that. And then the minute I pass away, I've named a successor trustee. Hopefully I've named several, so that in case the first one is not available, the second one, or death, incapacity, the second or thirds can step up. And there's literally no need for court. Okay, so this is a great way to keep families out of court and hopefully out of conflict, because everything's following the terms of this legal document. And if I'm a homeowner and I have rents that need to be collected, then the successor trustees have immediate authority to collect the rents, refinance, pay bills, whatever they need to do. It doesn't lead to any of the assets being wasted. So because the trust owns it. So it's just a transfer of the fiduciary and not ownership. All right, so we've kind of described this already. A living trust is a trust you create during your lifetime, also known as inter vivos. You've heard about it in law school. And it's a contract for how you want your assets to be handled after you die. And it also can cover incapacity, which is a really great tool, because sometimes some things happen. We become Alzheimer's, dementia, coma, stroke. Any of these things can affect our ability to control and manage our finances and our assets. The trust can go into effect upon incapacity, whereas a will only goes into effect when someone dies. The big question I get a lot is, oh, okay, was this going to protect my assets? Can someone still sue me if I put everything into a trust? So while a revocable trust is a powerful estate planning tool that avoids probate, it does not offer asset protection for the grantor. Okay, so I'm still in control. I can still write checks. My creditors can still come after me. Okay, so it's only when the trust is controlled by a third party, where I no longer have control of it, that I have the liability protection. So revocable versus irrevocable. Revocable is, I'm the grantor. I can amend it. I can change it. It can go into effect upon my death or incapacity, but I have no protection from the creditors, although I do retain control over my assets. An irrevocable trust, I can make only limited changes. I can usually only update the beneficiaries. So I've named my child, Now my child's not talking to me, I'm going to remove them from from receiving a gift. And I can change my trustees, right? So I'm suspecting that somebody's not acting right. All of a sudden, they're taking all these long trips to Europe without a job. I might have some concerns. I'm going to have them removed and replaced with someone else. The benefit of doing an irrevocable trust, especially a Medicaid asset protection trust, is I can qualify for Medicaid and those government benefits. So it's a really great tool. And again, if I don't have control, it protects the assets from the creditors. So if someone sues me, they cannot go after the assets in the irrevocable trust. But again, you have to surrender control of the assets in order to get the protection. So this is doesn't always work for every family, right? Not everybody has someone that they trust to manage their assets while they're alive. So it has to be sort of a discussion with the client. Does this work for you? So again, Medicaid trusts are a really great tool. If everyone could have them, that would be ideal. Again, you're transferring the assets out of your name into the trust run by a third party, the trustee. And then I'm still entitled to the income if it's my trust as the grantor, but I cannot change the trust. I shouldn't be moving assets in and out, right? Because there's look back periods, which is really a discussion for a different topic. But at some point I will qualify for Medicaid, and Medicaid will not be able to go after the estate for reimbursement if everything is done properly. But I still retain the option to change the beneficiaries and the trustees. One last trust to mention is a testamentary trust. Again, these are created through the will. So the will has to have the language that says I leave things to my child in trust, and that creates the testamentary trust. So the advantage is, if I have children, I don't want them to receive everything at 18. I'd rather a trust be created so that they receive it at 25 or 30 or graduating college. I can do that through the will. And the other, okay, so I guess I feel like it's kind of a disadvantage, but you have to wait for the death of the testator, and the trust only goes into effect upon death. So again, the disadvantage is you're putting your family through court in order to create the trust when you could have done an inter vivos trust during your lifetime. So families stuck paying the probate costs, dealing with the creditors, attorney's fees, etc. And it does not deal with incapacity, right? So if I've been incapacitated, the will is not going to allow someone to take over and control my assets if I need. So if you're involved with, family court, this is a great topic on estate planning when there's minor children involved, right? So main thing to know is children cannot inherit. A guardian, usually when there's another parent alive, so mom and dad have the child, mom dies, dad's going to be the automatic guardian. The courts don't necessarily get involved in a scenario in that regard. But if maybe you have a family case where dad's not around, or lost custody, or has very minimal custody, do we want that parent becoming the guardian of the child, or more importantly, the assets that the child is supposed to inherit? So this is a big thing that I like to point out to family law attorneys, is make sure, maybe having the client consult with an estate planning attorney for what happens if you die. Okay, so mom dies. Usually if you've done an estate, a separation agreement or a settlement agreement for the family court matter, there's language about life insurance for the ongoing child support for the lifetime until the child matures. So what happens when mom dies, dad's receiving the benefit of the life insurance, it's supposed to be used for the child, but dad's remarried and dad dies. Okay, now new spouse is entitled to some of that money, right? Which was not the intention of that agreement or the parties. So we would want to consider doing a trust instead, where the life insurance pays the money to a trust, and then the trust names the child as the beneficiary. And this way, if the other parent dies, there's still money exclusively for the child. Okay, also guardians, again, naming a guardian for the child in case the parent dies. This can only be done through a will. So you'll nominate the guardian in the will, and that'll be dealt with through the courts. So this is a great tool for parents because it gives them a say in who would raise the children, and it can help avoid a dispute if there's multiple petitions. You know, grandma wants it, but best friend wants it. Who's the court going to choose? They'll look to the parent's preference. All right, so getting into subtrust. So kind of as I mentioned, minors cannot inherit. So if the other parent is not around or alive, there would have to be a guardianship proceeding under SCPA Article 17, both for the guardianship of the child and guardianship of the estate of the child, the money that they're supposed to receive. So again, if you're doing family law, I really encourage you to speak with an estate planning attorney for parents of minor children, making sure that there's some system in place. And, you know, look through your settlement agreements, see if there's room to add a trust as in the language for the life insurance. Maybe both parents would agree that they don't want the other one receiving the money, and that both can set up a trust and have their respective trusts receive the money so that it really is for the benefit of the child and can't wind up somewhere else. And just in general, for parents, maybe they don't want their child to receive potentially a huge chunk of money at age 18, right? I don't know if I could have been as responsible with it then as I would now if I would have received it at 18. I remember going to college and first thing I saw was all the credit card companies signing me up for free credit cards and I get a free bag. So, you know, there's risk involved there. So with an estate plan, you can change the age for the inheritance. And we like to do like a distribution at age 25, 30, 35, so that they get a little bit and then learn as they mature and grow to manage it until they're old enough to really, you know, maximize the benefit of the inheritance. You can also name children as co-trustees so they can learn to manage the money, and you know, just avoid some of the conflicts if you're doing an estate plan when there's minor children involved. Another great reason to do subtrust, you know, beyond just for minors who are under 18, is that it can, if it's held in trust, the creditors can't come after it, right? So again, I go to college, I sign up for a bunch of credit cards, I don't pay them, they're going to come after me. I've received a big inheritance, it's in my name, it can all go to the creditors. But if it's held by a trust, it's not accessible to the creditors. What if I turn 20, I meet the man of my dreams, I get married, by 21, I'm divorced? Is there a potential for that divorcing spouse to come after me and make a claim on the inheritance? You know, it depends obviously how I use the money. But again, if it's in the trust, it protects from those kinds of creditors, and divorces. All right. So supplemental needs trust. So if you do any kind of personal injury stuff, you know, hopefully this will resonate with you. What is a supplemental needs trust? It's also referred to as special needs trust. It's aimed at enhancing the quality of life for the person who's hopefully receiving some kind of government benefits and will not lose those benefits once they receive an inheritance. Obviously, in some cases, people cannot manage their own funds, and so they'll need to have a supplemental needs trust. We want to avoid having these set up by the courts, right? So ideally, the parents are setting them up for their children, and then they have a say over who's going to be the trustee. If that's not done, then it's going to go through the courts. The courts appoint someone, and then they need permission to spend the money for the benefit of the beneficiary. So again, in personal injury cases, one thing I've seen, which is unfortunate, is you know, someone's injured, the attorney's working on the case, gets a great settlement, hooray, they write the check out to the client, but somewhere along the line, that client started receiving government benefits for disability. Now they're going to get kicked off of those benefits because they've just received a big chunk of cash. And then now they're having to create a trust to kind of undo what's done and then eventually reapply and get back on their benefits. So really important if you do any kind of personal injury work, just, have some kind of intake or checkbox. Make sure you're checking with your client, are they receiving government benefits or have they started receiving government benefits? If they are, we want to get them to an estate planning attorney, set up the supplemental needs trust, and then write the check payable to the trust. And hopefully they have someone that they trust who can be the trustee for them. All right, if you've listened so far, we're at the code. The CLE code to get your credits is creditors. So I'll give you a minute to write it down. All right, so I like to share celebrity estate stories because they're pretty relatable. We all kind of know these faces. So first one I'll talk about is Robin Williams. I'm just going to pull out the language that I found really helpful from this case. So good news is Robin Williams did do an estate plan. He did a trust, and in his trust, he was married. He was married for the third time at the time that he died, and he had children from previous marriages. And basically what happened is he left the house that he was living in with his wife to his wife, and all of the and everything else basically to his children. Okay, so if there's a trust, why are we talking about this, right? Why do I know about this? Well, because there was a dispute. And once there's a dispute, papers get filed with the court, the trust gets filed, and it all becomes public record. So what went wrong in this case is he specified that, his memorabilia, his clothing, right? Where do these things go? So his trust described he wanted his 3 children to get his clothing, jewelry, and personal photos taken prior to the marriage to the third wife, Susan, as well as memorabilia and awards from the entertainment industry. So he wanted all of that stuff to go to his children. Meanwhile, the wife is living in the house. She's got all this stuff, and she's saying, well, what do you mean memorabilia? And so this term becomes a conflict. So they wind up in court, she's saying, well, what about this stuff that we bought together? How are you defining these things? So it was not clear. Luckily, the matter settled, and the trust agreed to pay her and maintain the house and give her money to spend, and gave her some of the stuff that they acquired during the marriage, and then everything else went to the kids. So it's a good lesson in, even though Robin Williams did an estate plan and it looks like he did things thoroughly, there's so many little things to kind of think through. And if they're not thought through all the way, it could wind up in court, right? And so this is a big reason why we discourage, online, download your trust, because you don't have that person walking you through some of these scenarios. All right, moving on to Whitney Houston. So Whitney Houston, love her. She, as you may have remembered, was married to Bobby Brown. They had a child, Bobby Christina, and then they got divorced. So unfortunately, Whitney Houston died, tragic death, and she had done a will because I believe the daughter was a minor at the time. So she did a will, and in the will, she did a testamentary trust, right? She left everything in trust to Bobby Christina. And the terms of it said, I leave everything to Bobby Christina. She gets it into 3 distributions at 18, 25, and 30. And if Bobby Christina is not alive, it goes to my sisters. Okay, so far so good. We like this language. It has the distributions and it has the backup. So Bobby Christina does inherit a big chunk at 18. And then unfortunately, Bobby Christina dies the same fatal death as her mom at the age of 20, I believe it was. So Bobby Christina did not do an estate plan, which is probably a good idea, because if you remember, there was like this shady boyfriend who was maybe involved. So we don't know if she would have left it to him, but because she didn't do an estate plan, we know where it went. Any guesses? It went to Bobby Brown. So everything that was in Bobby Christina's name went to Bobby Brown, her father, because he through intestate laws in California. And of course, he didn't need it. And Whitney Houston, I'm sure, did not want that. So the saving grace, though, in this story is, again, that she did the distribution schedules, right? So only 1/3 of her estate went to Bobby Christina. The other 2/3 were still held in the trust, and they wound up going to Whitney's sisters. So it's a tragic story, but there was a good, result in the end because she took the time to do the estate planning and make sure she set up that distribution schedule. So this is why we really recommend that for parents of minor children. All right, so Hugh Hefner, picked him because he's popular. People kind of like to know what he's got going on. You really wouldn't know because he did a trust, and so it should be private. And the only reason we do know about it is because there was some intellectual property that wasn't properly transferred into the trust. And so with a trust, people usually do what's called a pour over will. And the will says everything in my name, in my estate, needs to go through the court and then be put into the trust. And so by doing that, the trust gets submitted to the court. If you Googled his trust, you'll see there's a lot of praise. He did a lot of things right. Which he did. He had a substance abuse clause that nobody could receive if they are using drugs, right? That's a good one. The one that I like and thought was appropriate that I wanted to share today is he expressly disinherits and excludes from any benefit under the trust any person who claims to be a child of mine, including any child of mine conceived after my death, unless such child lived with me in my household and was acknowledged by me in writing to be my child. So the beauty of, this trust is he really went into it, just in case someone's claiming that they're his child, he's limiting that, the ability for them to claim any inheritance. So again, normally we would not know what his trust says because it's a private legal document, but because it wasn't fully funded, there was something left out. It had to go through the courts. It becomes public record, and now we all know about it. Next on my list is Heath Ledger, great actor. Unfortunately died in 2008. I forget how old he was. I think he was in his late 20s or early 30s. Now, Heath Ledger had done a will, and so of course we know about it. And in his will, he left everything to his parents. Now, the problem in this case is that after he wrote his will, a couple years later, he had a girlfriend and he had a child. So he never updated his will. So big lesson to learn from Heath Ledger is you have to update your will, especially when you have big life-changing events like marriage, divorce, child, death, inheritances, etc. So because he did not name his child, and the will supersedes, right? So the will said everything goes to my parents. Now, fortunately, his parents settled with the mother of the child and agreed that everything, would be in fact for the benefit of the child, and they did some kind of other arrangement. But again, this is unfortunate that he took the time to do a will but didn't update it, and so it became public knowledge. Families had to get through the court system, and it's not private like he would have wanted. So a big advocate of trusts, and also trusts are much easier to amend than a will. We don't recommend amending wills through codicils, just recommend revoking and doing a new one if that's what you're going to do. But best to avoid court completely by doing a trust. So I went through my slides faster than expected, so I'll look through the questions. I'm not seeing the.
Would you like assistance with the questions, or would you like to just read them?
Let me see. I'll see if I can read some of them.
Sure, they should be under the Q&A box under open questions.
Okay, found
and
it.
just let me know if you need any help, though.
Okay, great. Thank you, Diana. So one of the questions is, can parents leave to children as joint tenants with right of survivorship or only tenants in common? So I think this goes back to my question about adding children to the deed during their lifetime. I mean, you can leave it to the children in either way. Obviously, joint tenants, JTWROS, as the person wrote. means it's an automatic transfer and they'll all be sharing 100%. If you do tenants in common, then they're only going to be getting whatever their share is, 50%, a third. I don't know if this is specifically for the TOD deeds, but we definitely, again, I don't recommend adding children to the deeds during the lifetime. Make sure that they inherit it. That's the key word, so that they get the step-up basis. But joint tenants or tenants in common, that's going to be based. The thing to know about with tenants in common is if it's not an automatic transfer to the other sibling. So if there's a spouse now and one of the siblings dies, the remaining sibling now owns it with that sibling's spouse. So you just kind of want to think through some of these scenarios when you're doing deed transfers. Okay. I think as people are adding more questions, it's throwing my box off. Okay, they're asking for a recording. There's handouts, so I think Diana can answer some of those later. Federal claims, someone pointed out, take priority over state claims. If a deed includes a child as a tenant in common, doesn't decedent's 50% interest go into probate? Correct. So if I own 50% and my child owns 50% as tenants in common, my death does not affect the child's 50% interest. So then my estate, my share would pass through them either through intestate or through my estate plan. If they're the only child, then they would inherit the other 50%, and then they would have a step-up basis on 50%. Can you provide the TOD, for example, to a child and then to the child's offspring should they child grant?
I'm sorry to interrupt you. I think you might be in the chat, which is where some people put questions, but there's a Q&A box with questions that might be easier to follow.
Oh, thank you.
You're not looking through all the chat stuff. Yeah, I'm sorry to interrupt you.
Got it. Okay. Okay, so after completion, somebody's asking, after completion of an estate and distribution, how do you close the estate file in surrogates court? Is there a checklist for closing? So I don't always recommend closing an estate, and I don't think it's a requirement. You definitely want to file the inventory of assets, or the asset inventory form. That's really important to show the court that everything has been paid and that the distributees or beneficiaries are now able to collect their distribution. But I don't always recommend closing the estate because sometimes stuff gets found later, especially when it comes to unclaimed funds. So yeah, I hesitate to close an estate unless it's, very sure, but I don't think you need to. Okay, someone's got a question about appearing as an attorney for an administrator, and whether they're still the attorney of record if a new attorney came on board. So yeah, you definitely would want to do a motion to the court to withdraw as counsel. So you would still be an attorney of record. Do judgments have to be docketed before the death to be enforced in probate? Good question. There's something else and medical bills. I believe so, but I think if you're somewhere near it, you might have an opportunity to show that that the case was pending and you were just waiting on the judgment. Ultimately what's usually winds up happening with the creditors is some kind of settlement discussions, because otherwise you leave it up to the judge and we don't know how the judge is going to rule. So if you're a creditor, you want to, basically reach out to the executor or administrator, and usually there's a settlement discussion. And what sometimes the executors say is, look, you could take a third or you could fight it out in court, but I'm going to give you a third. If we fight it out in court, the judge might pay everybody else and you get nothing. So, it's going to depend on how much is in the estate and what there is to pay. But there's definitely room for negotiations. If the decedent dies without a will and has no spouse, issue, or surviving parents, but has two siblings, one of which is now deceased, does the surviving sibling inherit 50% and the deceased sibling's children inherit the other 50%? Yes, I agree with that. If there's no will through administration, there's no lapsing. So it's just going to keep going until they find the next heir. Can you still do a deed transfer and retain a life estate? Does that give a stepped up basis to the transferees? Yes, because you retain an interest, and so they do get the step up basis through the life estate. Okay, sorry, this keeps moving. I think other people add it's changing it for me. Okay. If children are on the deed, but only as tenants in common, doesn't the parent have to leave the parent's portion to the child in a will? Right. So if the parents are on the deed with the children and everybody is tenants in common, that the parent's interest does not automatically transfer. So it would either if there's a will, they can designate it to the children, or sometimes it would pass by operation of law. We call it an heirs at law deed. For the surrogates court, real estate can pass without going through the courts, if that's the only asset, through what we call an heirs at law deed. So that's something you can speak to the title company about to see if this particular asset would qualify for an heirs at law deed. And that would not require necessarily going through the courts. It usually requires affidavits of heirships and to prove that those are the only remaining people that are entitled to inherit, and they can do the heirs at law deed transfer without having to go through the courts. Again, I would consult with the title company. We see these they're supposed to wait 2 years after the decedent's death. Sometimes we're able to do them sooner, but I feel like that's a courtesy that some title companies are allowing, but it's a risk because if there's an heir that didn't, got cut out intentionally, they're going to sue, and title companies are going to stop being lenient about this. So I would do that on a case by case scenario basis. Can a supplemental needs trust be named as a beneficiary on a transfer on death deed? Ooh, good question. As far as I know, the statute does not have trusts as beneficiaries. It has to be a person. That might be a great solution in the future, but I don't. Right now, the statute doesn't have trusts as beneficiaries for the TOD deeds. Okay, other than time involved in the probate process, what is the functional difference in terms of effectiveness between a TOD deed and a specific, I think it's supposed to be bequest of real property? So if you're doing a specific bequest, you're doing a will, the will has to be probated, right? You can't do an heirs at law deed that I just talked about if there's a will. Those are only when there's no will. So the will has to be probated. Once an executor is appointed, then the transfer can happen. So ideally, the TOD deed is going to be an immediate transfer upon death. And as mentioned before, some of these court processes can take a very long time. I try to tell people, don't die in the Bronx, don't die in Brooklyn, because they're very slow to process. There's just not enough staff and way too many filings, and everything got backed up during COVID, and they haven't been able to catch up. So it can take a very long time for the wills to be processed. So, in a scenario where there's not, the only asset is a house, there's not a lot of money for the family, maybe a TOD is the best option to avoid probate and all those delays. So is there ever a situation where it's preferable to have a will instead of an inter vivos trust? or irrevocable trust always the way to go for estate planning. So you definitely, again, need a will when there are minor children involved, because you want that vehicle to name the children, the guardians of the children. But even still, I recommend an inter vivos trust for the children, because again, you want to be able to name you want to try to avoid the courts if possible. And so if you don't need the will to designate guardians because the other parent is alive, then you want to try to do everything through the trust. But especially when there isn't another parent and you're going to need a guardian appointed for that child, you're going to have to do at least the will in that case. But again, I would still do the trust, because the trustee can manage the money for the child's benefit while that guardian is appointed, because the guardian and the trustee don't necessarily have to be the same people. For example, if I could, I would name, my wishes are held, I would name an aunt to raise my children, but she lives in Canada. So she can't be the trustee, because that would make my trust a foreign trust that's taxed at a higher level. So I have to name a different person to be the trustee while I want her to be the guardian. Okay, so that can really only be done through the trust. Okay, so I've indicated including a child on a deed avoids probate, whether it's joint tenants or tenants in common. Okay, I think this is a question I asked about before. So tenants in common, the parent can only transfer their interests. So if I misspoke, to be clear, the tenant can inherit sorry, the child can inherit if they're added, but yes, I guess I did, if I'm accurate, you're right. I state after this question, I don't know. But co-ops are really tricky, since you brought this up, for estate planning, right? Because a co-op transfer to a trust has to be approved by a board, by the management, the board. So not all co-ops allow a trust to own the shares. So it's really important, if you're talking to a client about estate planning and they have a co-op, they've got to check with the board to make sure that the co-op will allow the transfer and allow a trust to be the owner. Some of the bylaws are antiquated. They say only one person can own shares, and so that precludes a trust. And so it becomes a big problem. The co-op has to literally amend the bylaws. Not everyone's willing to do that. So in that case, there's different planning we can do, especially for Medicaid purposes, but it would still wind up in probate. All right, I've only got a couple minutes left. So asking me to clarify, does a revocable trust, where the grantor is not the trustee, provide asset protection to a grantor? So, generally the revocable trust, a grantor is the trustee, so they're not going to get the asset protection. The revocable means I have the power to change it. I'm in control. So generally, a trust that has the asset protection, I am not the trustee, and a third party is going to do that. And those are usually seen with the irrevocable trusts, supplemental needs trusts, different types of estate tax planning trusts that have third parties as the trustees. But again, if I control it, the creditors can come after me. All right, irrevocable family trust. Wife is the trustee. Can she, as she ages, turn the trusteeship over to an alternate trustee so that she has asset protection? Yeah, so hopefully there's language in a trust that says a trustee can resign. So you'd have to look to the terms of the trust to see what it says. But yes, ideally, if somebody is a trustee and there's a creditor coming after them, we want language in there that says that they can resign, which would give the assets protection needed against those creditors. Okay, so that we have 1 minute left. Diana, I don't know if I should keep going or.
Yeah, sure. You want to do one more question and then we'll wrap it up? If we did not get to your question, shoot us an email and we'll try to get it answered. So we'll do one more question and then we will wrap it up.
Okay, great, thanks. So last one, if the administrator or proposed executor doesn't know the address for a disinherited person, do they still need to be notified? Oh, in an ideal world, we could just say, I don't know their address. We don't have to notify them. So unfortunately, no. When this happens, there has to be a due diligence affidavit submitted through the courts, and generally a publication is required. So if all of those steps are done and the disinherited person doesn't show up, then they've lost their opportunity to contest the will. But everything has to be done through the courts to make sure that they've had notice. Thanks for the questions, guys.
Thank you. So even before the lecture, Leslie and I were talking about doing a part 2. And I think she broke the record for the number of questions asked in a CLE. So I think we might have to do a part 2. Thank you all for coming. Thanks for a wonderful lecture. It was really interesting. I piqued everyone's interest. I have about 100 questions, which I think is the most we've ever had.
Wow.
So maybe in the not too far future, we will do a part 2. It was lovely having you, and I thank everyone for coming.
Thank you so much for having me. It was great.
Thank you.